Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload new content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. Let's get right into it. Question number 1. David entered the county museum at a time when it was open to the public, intending to steal a Picasso etching. Once inside, he took what he thought was the etching from an unlocked display case and concealed it under his coat. However, the etching was a photocopy of an original that had been loaned to another museum. A sign over the display case containing the photocopy said that similar photocopies were available free at the entrance. David did not see the sign. Burglary in the jurisdiction is defined as entering a building unlawfully with the intent to commit a crime. David is guilty of A. Burglary and larceny, B. Burglary and attempted larceny, C. Larceny, or D. Attempted larceny. Take 10 seconds and think this through. If you chose option C, larceny, you'd be correct. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. Burglary, as defined by the statute, is entering a building unlawfully with the intent to commit a crime. In this case, David is guilty of larceny because David took the etching from the display case without permission and hid it under his coat with the intent to permanently deprive the museum of that etching. However, David cannot be guilty of burglary per the burglary statute unless he unlawfully entered into the building, which he did not. He actually, in fact, entered during regular business hours. As a result, David can only be guilty of larceny. Question number 2. Sue Starr, a minor, both in fact and appearance, bought on credit and took delivery of a telescope from 30-year-old Paul Prism for an agreed-upon price of $100. Upon reaching her majority soon thereafter, Starr encountered Prism and said, "I'm sorry for not having paid you the $100 for the telescope when the money was due, but I found out that it was only worth $75. So now I promise to pay you $75. Starr subsequently repudiated this promise and refused to pay Prism anything. For this question only, assume that Starr bought the telescope from Prism after reaching her majority and promised to pay $100 as soon as I am able. What effect does this quoted language have on enforceability of that promise? A. None. B. It makes the promise illusory. C. It requires Starr to prove her inability to pay. Or D. It requires Prism to prove Starr's ability to pay. Take 10 seconds and choose the best answer. Best answer is D. It requires Prism to prove Starr's ability to pay. If the language in the contract states something must occur before someone's performance is due and this condition is not satisfied, performance is then excused. There must be strict compliance with all conditions. In this case, if Starr bought the telescope from Prism after reaching her age of majority and promised to pay $100 as soon as I am able, the contract has an express condition that must be satisfied before Starr's performance is due. As such, this would require that Prism prove Starr's ability to pay in order to compel her performance. Relatively straightforward. Question number 3. Parr sued Davis for damages for physical injuries allegedly caused by Davis's violation of the federal civil rights law. The incident occurred wholly within the state of Chippewa, but the case was tried in federal court. The Chippewa State Code says the common law privileges are preserved and intact in this state. At trial, Davis called Dr. Webb, Parr's physician, to testify to confidential statements made to him by Parr in furtherance of medical treatment for the injuries allegedly caused by Davis. Parr objects, claiming a physician-patient privilege. The court should apply A. State law and recognize the claim of privilege, B. Federal law and recognize the claim of privilege, C. State law and reject the claim of privilege, or D. Federal law and reject the claim of privilege. Take 10 seconds and choose your best answer now. If you chose option D, you'd be correct. Federal law and reject the claim of privilege. The rule is that state privilege law applies in federal court civil actions based on diversity jurisdiction. Under the federal rules of evidence, there is no doctor-patient privilege. In this case, Parr sued Davis for damages allegedly caused by Davis's violation of the federal civil rights law. Since his action is in fact in federal court under federal question jurisdiction, not under diversity jurisdiction, the court will apply federal privilege law, and since there is no doctor-patient privilege recognized under the federal rules of evidence, the court should reject the claim of privilege in its entirety. Question number 4. Jack, a bank teller, was fired by Morgan, the president of the bank. Jack decided to take revenge against Morgan, but decided against attempting it personally because he knew Morgan was protected around the clock by bank security guards. Jack knew that Chip had a violent temper and was very jealous. Jack falsely told Chip that Chip's wife, Elsie, had been having an affair with Morgan. Enraged, Chip said, "What am I going to do?" Jack said, "If it were my wife, I'd just march into his office and blow his brains out." Chip grabbed the revolver and rushed to the bank. He walked into the bank carrying the gun in his hand. One of the security guards, believing a holdup was about to occur, shot and killed Chip. If charged with the murder of Chip, Jack should be found A. Guilty based on extreme recklessness, B. Guilty based upon transferred intent, C. Not guilty because he did not intend for Chip to be shot by the security guard, or D. Not guilty because he did not shoot Chip and he was not acting in concert with the security guard. Take 10 seconds now. If you chose option A, guilty based on extreme recklessness, you're on a roll here. Murder is the unlawful killing of another human being with malice aforethought. Malice aforethought exists if there is no excuse justifying the killing. No adequate provocation can be found, and the killing is committed with one of the following mindsets. A. Intent to kill. B. Intent to commit great bodily injury. C. Depraved heart killing. Or D. An intent to commit a felony. A depraved heart killing is the wanton and willful disregard of human life. The defendant was aware of the unjustifiably high risk to human life of her actions, but chose to proceed anyway. Here, Jack knew that Morgan was protected around the clock by bank security guards. Despite this knowledge, Jack falsely told Chip that Chip's wife was having an affair with Morgan and encouraged Chip to head into the bank armed with a gun. This is clearly wanton and willful disregard of human life, since Jack was aware of the unjustifiably high risk to Chip's life of going into the bank armed with a gun, which is the precise reason that Jack did not try to take revenge on Morgan himself. Therefore, Jack, in fact, would be guilty of murder based upon extreme recklessness. Question number 5. Tess Traviata owed Dr. Paula Pulmonary, a physician, $25,000 for professional services. Dr. Pulmonary orally assigned this claim to her adult daughter, Bridie, as a wedding gift. Shortly thereafter, on suffering sudden severe losses in the stock market, Dr. Pulmonary assigned by assigned writing the same claim to her stockbroker, Margin, in partial satisfaction of advances legally made by Margin in Dr. Pulmonary's previous stock market transactions. Subsequently, Traviata, without knowledge of either assignment, paid Dr. Pulmonary the $25,000 then due, which Dr. Pulmonary promptly lost at a horse track, although she remains solvent. Assuming that Article 9 of the Uniform Commercial Code, the UCC, does not apply to either of the assignments in this situation, which of the following is a correct statement of the parties' rights and liabilities? A. As the assignee, prior in time, Bridie can recover $25,000 from Traviata, who acted at her peril in paying Dr. Pulmonary. B. As the sole assignee for value, Margin can recover $25,000 from Traviata, who acted at her peril in paying Dr. Pulmonary. C. Neither Bridie nor Margin can recover from Traviata, but Bridie, though not Margin, can recover $25,000 from Dr. Pulmonary. Or D. Neither Bridie nor Margin can recover from Traviata, but Margin, though not Bridie, can recover $25,000 from Dr. Pulmonary. Take 10 seconds, see if you can figure this one out. I hope you chose option D. Neither Bridie nor Margin can recover from Traviata, but Margin, though not Bridie, can recover $25,000 from Dr. Pulmonary. An assignment is a transfer of the right to benefits under a pre-existing contract to a third party. The assignor is the party who makes the assignment. The assignee is the party who was not a party to the original contract, but is now the recipient of the assignment. The obligor is the other party to the original contract who owed performance to the assignor. Payment by the obligor to the assignor is legally effective until the obligor is notified of that assignment. Consideration is not required for a valid assignment, so gratuitous assignments are valid, but they also are freely revocable. Here, Traviata is the obligor who owed $25,000 to Dr. Pulmonary. Dr. Pulmonary is the assignor who assigned her $25,000 claim to Bridie as a wedding gift. This makes Bridie a gratuitous assignee. Dr. Pulmonary then assigned that same $25,000 claim to Margin in partial satisfaction of advances made by Margin in Dr. Pulmonary's previous stock market transactions. Since a gratuitous assignment is freely revocable, Dr. Pulmonary's reassignment of the $25,000 claim to Margin means Bridie is no longer the assignee. There is also no indication Bridie relied upon the assignment, so Bridie has no grounds to recover anything from Dr. Pulmonary. In contrast, Margin holds the assignment, so Margin may recover against Dr. Pulmonary. Traviata had no knowledge of either assignment when she paid Dr. Pulmonary the $25,000, so her payment was legally effective. This means Margin cannot recover from Traviata. Therefore, neither Bridie nor Margin can recover from Traviata, but Margin, though not Bridie, can recover $25,000 from Dr. Pulmonary. Question number 6. Let's see if we can get through this. Which of the following acts by the United States Senate would be constitutionally improper? A. The Senate decides with the House of Representatives that a disputed state ratification of a proposed constitutional amendment is valid. B. The Senate determines the eligibility of a person to serve as a senator. C. The Senate appoints a commission to adjudicate finally a boundary dispute between two states. Or D. The Senate passes a resolution calling on the President to pursue a certain foreign policy. Take 10 seconds and choose what you believe to be the best answer. If you chose option C, you'd be correct. The Senate appoints a commission to adjudicate finally a boundary dispute between two states. The rule is that the Supreme Court of the United States has original and exclusive jurisdiction over controversies between state governments. As such, the Senate appointing a commission to adjudicate finally a boundary dispute between the two states would violate the separation of powers. Question number 7. The prosecution of Dolly for assault. Wharton is called to testify that the victim, Valerian, had complained to Wharton that Dolly was the assailant. Wharton's testimony is most likely to be admitted if Wharton is A. A doctor whom Valerian consulted for treatment, B. A minister whom Valerian consulted for counseling, C. Valerian's husband, who she telephoned immediately after the event, or D. A police officer whom Valerian called on instructions from her husband. Take 10 seconds. Choose the best option. If you chose option C, Valerian's husband, whom she telephoned immediately after the event, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. The hearsay exemptions are admission of a party opponent, 2, vicarious party admissions, and 3, prior statements by a witness. The hearsay exceptions are excited utterance, present sense impression, present state of mind, statements of past or present mental or physical condition made for medical diagnosis or treatment, business records, and public records exception, as well as judgments and previous convictions. Present sense impressions are admissible if describing or explaining an event or condition made while the declarant was perceiving the event or immediately thereafter. In this case, Wharton's testimony would be hearsay because Valerian's statement is an out-of-court statement being offered to prove the truth of the matter asserted in that statement. As such, it must fit into one of the hearsay exemptions or exceptions to be admissible. Answer choice C is the most likely to be admitted here because it meets the requirements for a present sense impression, i.e., a statement describing or explaining an event or condition made while the declarant was perceiving the event or immediately thereafter. As a result, option C would be your best choice. Question number 8. Abel and Baker are students in an advanced high school Russian class. During an argument one day in the high school cafeteria in the presence of other students, Abel, in Russian, accused Baker of taking money from Abel's locker. In a suit by Baker against Abel based on defamation, Baker will A. prevail because Abel's accusation constituted slander per se, B. prevail because the defamatory statement was made in the presence of a third person, C. not prevail unless Abel made the accusation with knowledge of falsity or reckless disregard of the truth, or D. not prevail unless one or more of the other students understood Russian. 10 seconds and think this through. If you chose option D, your thought process is right on point. Not prevail unless one or more of the other students understood Russian. An allegation of fact in reference to a plaintiff that harms the reputation of the plaintiff by reflecting negatively on a character trait is a defamatory statement. This statement qualifies as defamation if it is published intentionally or negligently to a third person, either in durable form or fleeting form. Slander per se exists when the defamatory statement is about a crime of moral turpitude, loathsome disease, sexual misconduct, or adversely reflects on conduct in business, profession, trade, or office. Here, Abel's accusation that Baker took money from Abel's locker seems to meet most of the elements of slander per se. It was an allegation of fact regarding a crime of moral turpitude made in fleeting form that injured Baker's character for honesty. However, Abel's accusation may not meet the publication element because the accusation was in Russian and there is no information on whether the other students could understand Russian. All we know for sure is that Abel and Baker take an advanced Russian class. The publication element is met if a person other than the plaintiff understood the defamatory statement. Thus, Baker will not prevail in a defamation suit against Abel unless another student actually, in fact, understood the statements in Russian. Question number 9. Jack, a bank teller, was fired by Morgan, president of the bank. Jack decided to take revenge against Morgan, but decided against attempting it personally because he knew Morgan was protected around the clock by bank security guards. Jack knew that Chip had a violent temper and was very jealous. Jack falsely told Chip that Chip's wife Elsie was having an affair with Morgan. Enraged, Chip said, "What am I going to do?" Jack said if it were me, I'd just march into his office and blow his brains out. Chip grabbed the revolver and rushed to the bank. He walked into the bank carrying the gun in his hand. One of the security guards, believing a holdup was about to occur, shot and killed Chip. If charged with attempted murder of Morgan, Jack should be found A. guilty because he intended to kill Morgan and use Chip to carry out his plan, B. guilty because he was extremely reckless as to Morgan, C. not guilty because Morgan was never in imminent danger of being killed, or D. not guilty because Chip, if successful, would be guilty of no more than manslaughter and an accessory cannot be guilty of a higher crime than the principal. Take 10 seconds. Choose the best answer. This one's relatively straightforward. A. Guilty because he intended to kill Morgan and use Chip to carry out his plan. In order to prove attempt, the state must show that 1. The defendant intended to commit the crime that he was in fact charged with, and 2. The defendant took a substantial step towards completing that crime. Regardless of the underlying crime, attempt is always a specific intent crime. Murder is the unlawful killing of another human being with malice aforethought. Here, Jack intended to unlawfully kill Morgan as revenge for being fired. Jack got Chip to carry out his plan by taking advantage of Chip's temper. Jack lied to Chip about Chip's wife having an affair with Morgan, and then Jack planted the idea of killing Morgan in Chip's head. Jack's actions of manipulating Chip were substantial steps towards completion of Morgan's murder. As such, Jack should be found guilty because he intended to kill Morgan and used Chip to carry out that plan, and of course took a substantial step in that direction when he manipulated Chip into picking up the gun and moving forward. Question number 10, the last question in this grouping. On August 1st, Geriatrics Inc., operating a life care home for the elderly, admitted Ulster, who was 84 years old, for a trial period of 2 months. On September 25th, Ulster and Geriatrics entered into a written lifetime care contract with an effective date commencement of October 1st. The full contract price was $20,000, which, as required by the terms of the contract, Ulster prepaid to Geriatrics on September 25th. Ulster died of a heart attack on October 2nd. On a restitutionary action, can the administratrix of Ulster's estate, a surviving sister, recover on behalf of the estate either all or part of the $20,000 paid to Geriatrics on September 25th? A. Yes, because Geriatrics would otherwise be unjustly enriched at Ulster's expense. B. Yes, under the doctrine of frustration of purpose. C. No, because Ulster's lifespan and the duration of Geriatrics' commitment to him was a risk assumed by both parties. Or D. No, but only if Geriatrics can show that between September 25th and Ulster's death, it rejected, because of its commitment to Ulster, an application for lifetime care from another elderly person. Take 10 seconds and choose what you think is the best answer here. If you chose option C, no, because Ulster's lifespan and the duration of Geriatrics' commitment to him was a risk assumed by both parties, you'd be correct, and congratulations. Freedom of contract permits parties to bargain and create the terms of their agreement as they desire without outside influence from the government unless the contract is illegal or against public policy. Furthermore, a contract will be enforced if both parties to the contract assume the risk. In this case, Geriatrics Inc. entered into a lifetime care contract with Ulster, who was 84 years old at the time. Geriatrics Inc. assumed the risk that Ulster would live a very long time, and Ulster assumed the risk that he would pass away sooner rather than later. As such, Ulster's estate would not be able to recover all or part of the $20,000 paid to Geriatrics up front, because Ulster's lifespan and the duration of Geriatrics' commitment to him was a risk assumed by both parties to this contract. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Please like, subscribe, and ring the notification bell so you can be updated every time we upload new content.